This is Rehan Ali Muhammad, and this is another edition of Do You Know the Laws, brought to you by Rehan Ali Muhammad, PC. The topic for today is common contract clauses. Now, everybody signs certain contracts either for their business or for personal, and a lot of times what you do is you basically sign it, don't look at it, and you don't really look at it until there's a problem. So it's important for you, the first tip I would give to you as an attorney and a CPA is to make sure that you review the contract, because you don't know what's going to be in there and what's going to affect you and what the other party is actually responsible for. So today we're going to be looking at common contract clauses, and it's important to review the contract, and if you have a question or if you want to negotiate something, you need to do that beforehand, because once you sign it, it's already done. Because you don't want to end up in a lawsuit, you don't want to end up where the other party breaches and it may not have been a breach according to the contract. So the first type of clause that we're going to look at is basically what's called a merger and integration clause, also known as a zipper clause. Basically, if you think about a zipper, it zips up, and only what's in the contract, only what's written in the contract is actually what part of the contract. So what's going to happen is you're going to deal with someone who is selling you something and they may promise you something. For example, if you're going to get a used car from someone, maybe they're promising you an oil change over the life of the car, but it's not listed in the contract. If this clause is in there, merger and integration clause, basically that promise would not be part of the agreement if it's not written in there. So make sure that anytime you have any promises and you have this clause, which is called merger and integration clause, that it's also listed, everything they promise is also listed in the agreement itself. Otherwise, if you have to go to the court of law, they're not going to value that promise if it's not written in the agreement itself. The next type of clause that we're going to talk about is an indemnification clause. Basically, it protects one party from negligence of the other party. So if you're going to rent a hall from a hotel, or rent a room from a hotel, rent a conference room from a hotel, you'll see this indemnification clause very commonly in those types of agreements, and it's basically going to say that the hotel is indemnified from you, your party, an officer of your company, from negligence or gross negligence where it injures someone. So what they're trying to do is protect themselves, the hotel, protect themselves from your party, you doing something, a negligent act that may have harmed someone. A time of the essence clause is very different, and that is basically if it's listed in the agreement as time is of the essence, that means that if the contract is not done, the services are not provided exactly on time, then you could be liable. Normally, if a time is of the essence clause is not in the agreement, then all clauses in the agreement, unless otherwise written, is always perceived to be what's reasonable. So if it's not listed as time is of the essence, basically, and it has a date on there where the agreement, the services need to be provided, if there's no deadline, or even if there is a deadline, but this clause is not in there, that means that if you finish the service within a reasonable amount of time from that date that's written there, then you're going to be fine. But if the time is of the essence clause is in there, even 1 day late is going to be a breach of that agreement. So you need to make sure if the time is of the essence is in there, that you meant it to be in there, or that you're aware of it before you proceed. Severability clause is very common. Basically what that is it says that even if a judge or a court or an arbiter finds one of the clauses in the agreement, the contract, to be invalid or unenforceable, then the rest of the contract is still valid. So it's very important to have this clause in an agreement that you're a part of, because if one part of the agreement is held to be invalid by a judge, you don't want the rest of the contract to also be invalid, because it basically ruined the agreement just because of this one one action by a judge. A non-waiver clause, the best way to explain this is an example whereby, for example, if you're renting an apartment from an apartment complex, and your rent is due on the 3rd of the month, and you're always late, and the agreement says that if you're late, you have to pay a penalty or interest or something like that, or you could be in default. But the landlord consistently accepts your payment late and does not charge you. A non-waiver clause, without that non-waiver clause, if he continually accepted that late payment, then what he's doing without this clause is he's amending the agreement to where it's okay for you to pay late. But if this non-waiver clause is in the agreement, then even if he is accepted a few months late and not charged you the late penalty, later on, 5 months, 6 months down the road, when you continue to do this, he can ask for the late payment at that time, because the agreement, because of this non-waiver clause, it means he has not waived that clause out of it just by actions. A liquidated damage clause is very important. Whenever you sign an agreement that has a liquidated damage clause, you need to be very careful, because if you violate an agreement and it has a liquidated damage clause, they could have a large amount where if you breach the agreement, you have to pay this large amount. Now, important thing to remember about liquidated damages clause is it cannot be unreasonable. Like I said, all contracts are interpreted using the reasonable standard, which is by the UCC, unless it's written in the agreement otherwise. You can always negotiate or change an agreement from what is originally presented to you, but you need to try to do that beforehand, or you need to follow the procedures in the agreement that says if you do certain things, you can amend the agreement. So the liquidated damages clause basically could say that you owe them $100,000 if you violate the agreement. Now, it's important to know that, again, if it goes to a judge is going to look at it in the reasonable standard, and if the damages actually to the other party were only about $1,000, but the liquidated damages clause say you owe them $100,000, the judge is probably not going to accept that $100,000 and may invalidate it, or may just change it to $1,000. The last clause that we're going to talk about is very important when it comes to a house or a rent of an apartment, something like that. It's called an acceleration clause. Acceleration clause is very simple. It says that if you default the agreement in any way, for example, you don't make a payment or something like that, or you're late more than once, then with an acceleration clause, you may be liable for the entire amount under the agreement right away. So that is very important. You need to make sure that you review all of the agreements, all the contracts that you sign, and all the clauses. If you do not understand any of the clauses, you need to make sure that you take time to review it, or you have an attorney to review it, because I've seen many contracts that end up in court because one party did not know what they were signing, and sometimes they can get out of it, sometimes they can't. But the best way to protect yourself is to have the contract reviewed by an attorney before you do sign it. So this is Rehan Ali Mohammed with another version of Do You Know the Laws? Thanks.